I&M.
There's nothing when under a for-cause removal standard, there is no pre-office conduct that could constitute cause.
That is my frontline response. I happen to have a backup argument, which is if you pick up the common law, then you would pick up.
Well, let's take your frontline argument first and see how far you're willing to go. Suppose that the office holder was permitted to resign from a previous job under a non-disclosure agreement based on long and egregious pattern of sexual misconduct. That would not be for cause. That would not be cause for removal.
So what I would say, Justice Alito, is I don't think that would be I&M. And so if I'm going to stick to my frontline position, then that would not be for cause. It would certainly be a basis for impeachment. And I think in understanding why we've had I&M for at least 90 years.
All right, I understand your position. How about if after the person assumes office, videos are disclosed in which the office holder is expressing deep admiration for Hitler or for the Klan?
I can only imagine where these typos are going to eventually go, Your Honor.
Well, yeah, because your position
I'm going to stick with my position.
Well,
of course I'm going to stick with my position. And I'm going to say that's an official that would be impeached in a heartbeat, and the fact that they would be impeached in a heartbeat is going to cause them to resign in half a heartbeat. And this has not proven a problem. I mean, for better or for worse, whatever you think of Humphrey's executor, we've had 90 years
Mr. Clement, what's your backup argument?
My backup argument is the common law standard. Justice Sotomayor alluded to it, which would be that there's a removal basis for an infamous crime of the kind that is disabling for public office, and and at common law it also required a conviction. So it's an exception. It helps me with a couple of these hypotheticals.
No, it doesn't
but it's
help
not going to help me with the Justice Alito.
It doesn't help
saying
you.
There's no conviction for the Hitler video.
Do you have a backup to the backup?
Impeachment. It's the ultimate backup here. This is not a situation where you're being asked, have to tie yourself to the
been argued in the past that impeachment doesn't cover private conduct. You obviously disagree with that, then.
Well, I certainly see, but this actually kind of makes the point about judicial review, right? I mean,
I'm not saying I agree with that, by the way. It's just been argued.
Right, but what I absolutely agree with is the Walter Nixon case says that there's no judicial review of the impeachment determination in the end. So whatever the House and the Senate ultimately determine, I mean, they can make constitutional law too, and they can determine whether private conduct is or is not out. And if they say, and with these hypos, I mean, and we can go down the road of the hypos and they'll get worse. The
backup to the backup, to use Justice Gorsuch's term, would be the infamous, but you don't need a conviction.
Right. No, absolutely. And of course,
that seems to solve answer a lot of the difficult hypos, correct?
Correct. But the reason I want to spend at least a moment answering some of the hard hypos is not because I'm a masochist. It's just because those are got to be the answers under I&M.
Your answer is that those are funneled to the impeachment process.
That's right, and that's the way I&M has worked for 150 years, and I think it would continue to work. It hasn't proven a problem in practice, but I'm not resisting very hard the backup to the backup on that because I don't think we're close. And of course, look, all of these are hard questions, which is all of the reasons why it's kind of crazy to decide this on an emergency application.
Yes, well, there are a million hard questions in this case, and it is an emergency application, and very difficult questions, either no precedent or very conflicting or very uncertain body of precedent. But there are two things were decided by the lower courts. One, that what I just explored, the district court said it's got to be in-office conduct, nothing that happened before person took office counts. And then the D.C. Circuit said that your client had a property interest in her office, and therefore a due process right. Is that right? She had a property interest in being a governor on the Federal Reserve Board?
So I think there's a perfectly reasonable argument for that, but I also think that there's a better argument that's a constitutional avoidance argument. And what the D.C. Circuit did in a per curiam opinion is sort of an example of what happens when you're trying to rush all of this, which is you jump right to a constitutional holding when there may be a perfectly good constitutional avoidance statutory holding there. And I think we've now had a couple of months and a bunch of amicus briefs to ventilate some of these things. And I think you get, with that ventilation, you get an understanding that there is a very good statutory argument. And I do want to talk about best reading a shirt left.